On May 22nd, three of Donald Trump's own Republican attorneys general walked into federal court and sued Donald Trump's own Department of Justice over cannabis, Nebraska, Indiana, and Louisiana, two medical-only states and a prohibition state. Their lawyer pool now includes Bill Barr's law firm. This is the strangest civil war on the conservative legal right in 20 years, and it is happening in the D.C. Circuit right now. I'm Patrick Nolan. Today on Pat Talks Law, the three Republican AGs suing over the marijuana rescheduling, and the surprising reason Trump doesn't care if he loses. Blanche signed the order, rescheduling of FDA-approved products containing marijuana from Schedule 1 to Schedule 3. 6 days later, on April 28th, the order ran in the Federal Register at 91 Federal Register page 22,714. The order took effect immediately on publication. State licensed medical cannabis, FDA-approved drug products containing marijuana. Both moved that day, but he skipped the notice and comment period. Adult use cannabis was carved out and routed through a separate administrative law judge, hearing scheduled for June 29th. We covered the DEA portal and what it meant for state licensed operators, link in the description. Today, three state AGs are trying to blow the whole thing up. The legal hook he used to skip notice and comment was a single convention on narcotic drugs. That is a 1961 international drug treaty the United States ratified in 1967. The acting AG's theory was that the U.S. has international obligations under that treaty, and that Section 811, Parent 1 of the Controlled Substances Act lets him reclassify drugs by order, not by rulemaking, when treaty compliance is at stake. He cited a 2024 Justice Department Office of Legal Counsel opinion that said Schedule 3 satisfies those obligations. That's the procedural shortcut. That's what got sued. Failed in the U.S. Court of Appeals for the D.C. Circuit because, of course, it was. Trump's batting average in the D.C. Circuit makes Little League teams look like the Yankees. Case number 26-1130, 15 pages. Petition for review under Section 877 of Title 21 Federal Rule of Appellate Procedure 15. Three petitioners: the state of Nebraska, Attorney General Mike Hilgers; the state of Indiana, Attorney General Todd Rokita; the state of Louisiana, Attorney General Liz Murrill. The respondents are the Department of Justice, Acting Attorney General Todd Blanche, the Drug Enforcement Administration, and DEA Administrator Terrence Cole. The legal theory is four-part. The agency action fails the Administrative Procedure Act. It exceeds the Controlled Substances Act. It conflicts with the single convention, and it is arbitrary, capricious, and not in accordance with law. Look at the dates. April 22nd, Blanche signs the order. April 28th, the order publishes in the Federal Register and takes effect. May 4th, SMART approaches to marijuana, and the National Drug and Alcohol Screening Association filed the first petition for review. On May 22nd, Nebraska, Indiana, and Louisiana filed the second petition. May 27th, the D.C. Circuit consolidates both cases under case number 26-1106. Briefing schedule: SAM and NDASA's opening brief is due June 4th. The state's opening brief is due June 26th. The DEA's separate administrative law judge hearing on adult use rescheduling begins June 29th, 1 month from the order to two consolidated federal lawsuits. That is fast for any agency action, let alone a rescheduling fight. If this is the legal news you want in your feed, hit like and subscribe now. The SAM and NDASA petition is signed by attorneys at Torredan Law. Bill Barr, who ran the Justice Department in Donald Trump's first term, is a partner at Torredan. SAM announced in January, just after Trump signed his executive order directing officials to expedite rescheduling, that it was hiring Barr's firm to fight the result. So the lineup is a Republican Justice Department under a Republican president doing what that president ordered, sued by three Republican attorneys general, and by a prohibitionist nonprofit represented by Donald Trump's former attorney general. If it was a Hollywood movie, nobody would believe it. Barr, again, on May 27th, the D.C. Circuit consolidated the two petitions on the court's own motion. Same panel, same record, same briefing schedule. Both challenges joined. The SAM and NDASA side argues the order is procedurally improper because the acting AG skipped the rulemaking process. The three states make the same procedural argument and add a federalism layer. Two paths to the same outcome: vacate the order, force the rescheduling back into normal APA procedure, including notice and comment, which would take months at minimum. Bottom line, the merits fight will live or die on the 2024 OLC opinion. That opinion, written under the prior administration, concluded that if marijuana is listed in Schedule 3, Most of the single convention's obligations are met by existing CSA authorities, and Schedule 3 controls are sufficient under the Convention on Psychotropic Substances for Delta 9 THC. Blanche reached into that opinion to justify using Section 811, Parent D, Parent 1, the treaty pathway. The petitioners will argue the OLC opinion is wrong, that Section 811, Parent D, Parent 1 does not give the Attorney General a roving authority to reclassify drugs by order, and that even if it did, the APA still applies. Here is the cleanest thing about Blanche's order. In August 2023, Health and Human Services completed a months-long medical and scientific evaluation and concluded cannabis as currently accepted medical use and that its abuse potential is lower than substances in Schedules 1 and 2. Blanche acknowledged that finding in the April 22nd order. He said he was exercising his discretion to pick the schedule that, quote, best positions the United States to carry out its obligations under the single convention. So the science said one thing, the treaty pathway said another. He chose the treaty pathway. Little known fact. Treaties outrank administrative practices. That is what the DC Circuit is really being asked to decide. I hate the this changes everything, AI marketing crap, but in this case it does. If the Administrative Procedure Act trumps the treaty, the president has the out he wants from a dozen or more international treaties. This case doesn't just change the temporary scheduling of marijuana, it realigns international power and relations. If he wins, Trump is the president who not only freed the flower, he knocked the prohibitionists on their butts. It is literally the fight Trump loves to be in, because he can't lose. And that is a masterclass in setting the field. 3 dates to watch. June 4th, SAM's opening brief. June 26th, the state's opening brief. June 29th, the DEA's separate hearing on adult use rescheduling begins. 3 forks of the same fight. What's actually being litigated here is procedure and high-level international politics. Whether an acting attorney general can ever skip notice and comment rulemaking by saying a treaty made him do it, or whether President Trump can start unilaterally walking away from international treaties. If the DC Circuit says yes to Blanche, the next thing he reschedules by order could be anything. If the court says no, NATO might have its walking papers. Keep an eye on the docket.